Our final argument for the morning is Petro Evaluation Service versus Shannon, Poff. It's case number 19AP0021. Both counsel are present. So each of you will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. Let me know, and I will try to help you keep track of that time, although it is posted on the television set over there to the right. We do videotape the arguments and play them on our YouTube channel, so we ask that you stay at or near the podium and keep your voice up. We've read the briefs and we are prepared to proceed if you are counsel.
Thank you. May it please the court, my name is Brent English. I represent Shannon Poff, who is the appellant in this case. I would respectfully reserve 3 minutes for rebuttal.
All right, thank you.
Your Honors, I know that you've read the brief, but I think it would be important to at least outline very briefly what the facts of the case are. My client, Shannon Poff, was married to a gentleman named James Poff in 2012. In 2015, particularly in October of 2015, Mr. Poff passed away, leaving Mrs. Poff with the job of administering his estate. She was appointed as the executrix of his estate, and one of the assets of the estate was an undeveloped parcel of real estate, several acres, that was in Congress Township, actually within the village of Congress in Wayne County, Ohio. On that property, there was some construction equipment owned by James Poff, and also a variety of what she regarded to be basically scrap metal that had been left on this site over a period of time. The record shows clearly that she had no idea that an entity called Petro Evaluation Service, Inc. claimed to own, or in fact did own, anything that was left on Mr. Poff's property. The record shows that there was never any lease between Petro and James Poff. There was never any agreement, at least of record, with respect to the storage of these materials on that site. Nevertheless, approximately or more than 6 months after Mr. Poff passed away, and after the period of time for making claims against an estate had run, Petro Evaluation Services sued Shannon Poff in her individual capacity, alleging that she had converted allegedly expensive oil field equipment that was rusting away on this site that allegedly belonged to it. So the issues were then joined. The claim was not only for conversion, but for alleged negligence by Shannon Poff in disposing of some of these materials. The record shows, I'm sorry.
I'm just curious as to any monies she received for these scrap metal. Did it go into the estate or did it benefit her personally?
Went to the estate.
It did go into the estate.
Correct.
She did list the materials in the inventory as well.
Correct.
How did she come up with the value?
She went there with a gentleman who had some knowledge about scrap metal to determine if any of this could be sold by itself or whether it should simply be scrapped.
Was she aware of any business relationship between Petro and her husband?
She had some knowledge that her husband had previously done some work for Petro on various oil locations that Petro had. Her husband was kind of the jack of all trades. He did excavation, he did a lot of other things. And so he had been engaged periodically, although not during their marriage, with working for Petro.
And I would imagine there was no, obviously no claim against the estate. Was there a letter or any sort of contact between Petro and Mrs. Poff?
No claim whatsoever within the 6-month period of this, and then there was a letter sent saying that you have.
After the 6 months.
Right. Well, let me explain a little bit more. The record evidence shows that my client went there with this guy named Bartram for the purposes of assessing what to do with this site. So all this metal is on this site. She's not sure what to do with it. She had no expertise whatsoever in dealing with this material. So this gentleman advised her that she should simply scrap it. And she was living in Florida, still does. And so she authorized her colleague, or she's not really agent in any way other than ask him to enter into a contract with a scrap metal person to come to the site, clear off whatever's on that site, get rid of it, and to move a couple of pieces of heavy equipment that belonged to James Poff that she intended to sell as part of an auction sale for the estate over to her real estate in Wayne County. That occurred. And in the middle of that process occurring, a representative who apparently is no longer alive showed up at, Representative Petro showed up at the site, brandished a weapon, claimed that this property was allegedly owned by Petro, and all work stopped. My client then paid the scrap metal provider back $1,900 out of the $5,000 that she had received, and basically sat tight while the situation unfolded. This litigation then ensued, and the litigation went on for a significant period of time. I was not Ms. Poff's trial counsel until January 29th of 2018, when I took over this case from a gentleman named Jerry Gullop, who was a lawyer in Canton. When I got involved in the case, the status was that there had been a motion for summary judgment filed against Shannon Poff, which had been denied. There were essentially default judgments against the other defendants who had been sued, the scrap metal dealer. The person working for the scrap metal dealer had been sued by Petro, and they had essentially defaulted, and judgments had been rendered by the trial court in that respect. So the record shows that we quickly asked for the file from Mr. Gullop, and we were substantially delayed in receiving the file for a period of about 5 months for no explainable reason. And one of the things that we discovered was that there was an outstanding request for certain discovery. The discovery related specifically to tax returns that James Poff filed between 2010 and 2015, which had been provided by Shannon Poff to her former lawyer, who was supposed to provide them during discovery. However, it appeared that he had not provided these tax returns, despite her giving him the originals of these tax returns. And so therein was the problem. So at a pretrial conference, Mr. Richard raised the issue of still these outstanding discovery requests, and at that point I indicated that I had been attempting to obtain the file from Mr. Gullop, that we would obtain the file. We did not need the court's assistance in obtaining the file at that point. Frankly, I thought any lawyer would cooperate in handing over this file, and I had personally spoken with Mr. Gullop, as the record shows, and he had promised it, but I just hadn't received it. However, over the next several months, repeated efforts were made to obtain this file, and the tax returns, which is really what we wanted out of the file. We had already reproduced the rest of the file from the court's website. And ultimately, the file was produced after a lot of effort on our part, and including being told that the file was so extensive that we would need a forklift to pick it up. I sent a messenger to Canton, picked up that file, and there are no tax returns in the file. And as a result of that, we went on a new effort to find the tax returns. We ultimately found the tax preparer who had prepared the returns, who thankfully was able to produce the tax returns at that point, and we immediately submitted them to Mr. Richard. The theory of the discovery request was that the tax returns would reveal whether or not, and this is a theory that I can't possibly understand, but this is the theory, that if Mr. Poff owned these materials on the site, he would have been depreciating them, and if he didn't depreciate them, then the jury could conclude that he didn't own them. Now, this is scrap metal. How you would ever depreciate scrap metal is beyond me, but that's hardly a capital asset. But nevertheless, that was the theory that was being pursued here. We then produced the returns. The trial court found that sanctions were appropriate against Shannon Poff for not having produced those returns, despite the facts that I've indicated. And
How close to the trial date are we at this point?
We are approximately 6 weeks from the trial date. So the tax returns are produced. They are of no relevance in the case. They were never used in the case, as you could certainly understand, as I just pointed out. But nevertheless, they were produced. And nevertheless, the trial court determined that a sanction of a default judgment against Shannon Poff in her individual capacity was appropriate, and over our objection, simply had the jury determine whether or what the value was of the property on the site. That is the sole thing that the jury ultimately determined. In our assignments of error, we first of all allege that there is no claim made against this estate. That claim is clearly time-barred. There was never a claim made against the executor of the estate with respect to this matter, and the plaintiff readily agrees with that fact. So the issue first is whether or not an individual acting on behalf of an estate can be held liable individually for conversion or negligence as a result of the facts that we've indicated. There is a case decided by the Fifth Appellate District that I cited in my brief that appears to be on all fours, that holds that as a matter of law, an individual is not liable for acts undertaken in a representative capacity. And that is wholly logical. Because if an executor or a fiduciary of any kind can be held liable for individual acts undertaken in their capacity as a fiduciary, then we have greatly expanded the role or the liability of fiduciaries, and no one would actually want to be a fiduciary if they could be sued for acts undertaken in their individually for acts undertaken in their representative capacity. That is illogical, but that is the theory that has been asserted in this case. That's the underlying theory. I submit that as a matter of law that is wrong, and that a fiduciary acting in his or her representative capacity cannot be held individually liable, period. So that's the first issue. The second issue in this case that's raised in the second assignment of error relates to the draconian sanction that was issued against my client for not producing tax returns that she gave to her prior lawyer, who lost those tax returns and never produced them for a period of 5 months, when she then went out and found the tax returns again and produced them well in advance of the trial. This court's precedent indicates, in the Morgan Adhesives case, that a discovery sanction of this kind can only be meted out if there is willful conduct by a party. And the sanction can only be proportional to the degree of misconduct, if you will, or lack of participation, if you will, in discovery. So the record shows that not only did Shannon Poff receive and answer in a timely way all discovery propounded to her, she sat for a deposition, she did her own discovery of the case, and the only issue relating to discovery pertained to these tax returns, that they weren't her tax returns, they were her former husband's tax returns from 2010 to 2015, which she timely produced to her lawyer for production, which were never made, and then apparently lost. Am I out of time?
You got 2 minutes and 58 seconds if you want to reserve it, or you can continue and I'll start it up again.
I'll tell you what, I will reserve the remainder of my time.
Okay, you'll have 2 minutes and 58, 2 minutes and 58 seconds for rebuttal. Counsel, you'll have 15 minutes.
Thank you, Your Honor. Good morning,
Morning.
Counsel. My name is James Richard. I represent the plaintiff in the trial court and on appeal, Petro Evaluation Services. With the court's permission, I will refer to the plaintiff as Petro, just for abbreviated purposes, and if I may, I'll refer to the defendant either as Shannon or Poff, just so we don't have to repeat everything. As often is the case, Your Honors, there is a dispute of fact. I respectfully disagree with the summaries that my colleague has given you. I will try to address what I believe to be clear and undisputed facts with regard to these assignments of error. First of all, the 12b6 motion, clearly one was filed, and as this court is well aware, it clearly states textbook elements of a claim for conversion, as well as a claim for negligence, and for that matter, other claims. And a motion to dismiss under 12b6 just tests the sufficiency of that complaint to state a claim. And as this court is aware, when a 12b6 motion asserts that the claims are time-barred, it must be, as you know, conclusively demonstrated from reading the pleadings alone that the statute precludes any claims as a matter of law. There is, the denial of the motion to dismiss was correct. The facts in the record at that time and subsequent to that time support it. What has been omitted is, and it's clearly in the record, is that Shannon Poff individually signed a contract with this salvage company to sell this oil field equipment. It's been called by her as scrap metal. It's not. The deposition testimony, which is really not part of these assignments of error, clearly shows that in pictures. We have large tank batteries, pumping units, storage tanks, not pieces of small metal sitting on the ground that were cut up with a torch. The contractor actually produced some, and Petro did. These items were not disputed, so the scrap description, I guess you could use for descriptive purposes, but they were large green storage tanks that you all see driving down the highway, and other items that are cut up and thrown into a huge dumpster and hauled away with tractor trailers. So that is what exists as a matter of the record. And the other issue that was brought up in my colleague's argument is simply incorrect. At the time this complaint was, well, as I mentioned, Shannon Poff signed this contract individually.
Can I ask a question about
Yeah.
that? Were those contracts signed while the estate was open?
Yes,
Okay.
I believe so, because I have to double check that. I hesitate to make it was after, because we found the contract, and that's why we commenced the action, because Jim Poff died in 2015, and it was after that, and that gets, Your Honor, to another issue. Even if it were a probate asset, property vests at death to the sole beneficiary, as you well know, which is, in this case, was the spouse of this marriage. Now, but what happened in the probate proceedings, because we checked that, there had been a partial inventory filed, and the proceedings were somewhat stale, and there was no listing of any oil field equipment on that inventory or scrap metal. Petro, in addition to filing this complaint, filed an application with the court to state that it wanted, because it didn't want any subsequent claims, all of the assets to be properly identified, because we had notices of auction sale, and we had claims that some of these assets had been taken from ours, had been taken from this yard and put elsewhere. All of that existed, and there was no inventory, Your Honor, and the $5,000 is not listed. Now, that's in the deposition exhibits, and it's in the affidavits, and I'm sure you can see that, but I represent to you as officer of the court that there was no, on the initial inventory, and and on the second inventory, nothing's listed. No cash from this sale, none of this equipment. And in fact, there's an argument at one point that some of this stuff might have been Jim Poff's equipment or his company's equipment, but he gave it to her. But the bottom line is it was an individual contract, and I submit that that is clear.
But there was no claim, Petro made no claim against the estate while the estate was open.
The estate is still open. It's incomplete, and the inventories haven't been completed. And we have intervened post-judgment to assert our judgment lien, because that's not in this record. But I'm just trying to answer Your Honor's question. But we did not file a claim because the sales contract was an individual sale by Shannon Poff to these people, and her deposition testimony actually even shows that it was a mistake. She claimed to be innocent or without knowledge, but, and to go back, Your Honor, to your one question, during these proceedings, there was a third inventory filed, and that's the last thing that's happened to this, where they list scrap at zero value, not $5,000. But this is after our claim has been pending for months. So I submit to you on the first assignment of error, looking at the claims, they clearly state a claim, and they clearly, there is nothing on the face of these claims to show it was time barred. And as I mentioned in my memorandum, the other significant fact is this ruling attesting the sufficiency of the evidence didn't preclude my colleagues from filing a motion for summary judgment. There's no waiver of the statute of limitations. They asserted it as a defense like we all do. They did not file a dispositive motion. After discovery, they didn't come in and file a motion for summary judgment. This issue just resurfaced on appeal as an assignment of error. We had, from this initial ruling, approximately 6 or 7 months before the discovery cutoff date arrived for them to file a dispositive motions, and as was mentioned, we did file a dispositive motion. They elected not to do so. So if they're arguing, I don't believe it's a proper argument. The argument, they were prejudiced by this early ruling. They had the right to discover this case, come forward, and they did, and say, hey, this claim is time barred, and that did not happen. Now on the sanctions, I have to state something first. I've been doing this a long time. I have never seen this type of discovery misconduct, and I state that candidly. This trial judge is experienced. He doesn't have a history of imposing severe sanctions. He gives everybody an opportunity to respond. But I want to state briefly what happened here. It's in my statement of facts. We start with initial consuls receiving from me what I call Rule 37E notices saying you're late on your discovery responses. No response. He does then file a motion with the court for stay, claiming his client, Ms. Poff, is being uncooperative.
Now, at this point, you're dealing with the Canton attorney?
Correct. That was Mr. Gowell. He filed, the Canton attorney, Mr. Gowell, filed a motion to dismiss saying, I'm having a problem, which we all have done when clients are being uncooperative, and I can't find my client, she won't respond. The trial judge denied that motion for stay, but indicated, and this is in the order that's in my appendixes, that we could discuss that at the status conference on January 18th. We did discuss it. He indicated that, and it's in one of the orders, if you don't receive any cooperation, he was going to file a motion to withdraw, and he did not do that. I then heard nothing after the status conference, filed a motion to compel, a motion for sanctions, and a supplemental motion to compel and sanctions. There was no response from counsel to that until the March hearing on all the motion to compels. Now, at that hearing, none of this evidence of sunrise came up. As I indicated in my memorandum, there were the statements saying Mr. Gobble is being uncooperative. He won't give us the file. I brought up, since I've been waiting for discovery for months, I said you could order tax returns for the companies of Poff and the individual returns of Poff from the IRS. We all know that. We're wasting time on discovery. Just fill out that form. I cited the number in my brief. You can have it for a $12 filing fee. They didn't do that. They just came in and said, I'm having trouble. I don't want to go to the expense of reproducing these truckloads of documents. They did say that. And the trial judge said, fine, I'm going to issue an order or orders. If you can't secure the cooperation of initial counsel, let me know. I'll issue an order and I'll direct him to bring those documents to the courthouse. That's in, and he summarized that in his next discovery order. There was then on April 30th, there was then two orders issued by the trial judge. He found my motions to compel to be well taken, did not impose sanctions, but ordered Ms. Poff and her counsel, present counsel, to respond by April 30th. He also issued an order setting this positive motion cutoff dates and a trial date and said, get this discovery completed. Between January 18th In March 26th, there was no response to any of the motions and memorandums the plaintiff filed by counsel. Nothing, not one word. After the March hearing, there was no notice from counsel or Ms. Poff saying, Mr. Gallo is being uncooperative. I can't get the document still. Please issue that order. There was simply nothing. April 30th comes and goes. I file the second supplemental motion to compel, a motion for sanctions. And I recite in my memorandum the relief we're requesting, which was ultimately ordered. What is amazing, based upon my experience, is when I get motions for sanctions and motions to compel, I at least respond. I say something in good faith, as I'm authorized to do. Under Rule 37, as we all know, we have to try to resolve these issues. I sent those notices to present counsel and former counsel, not one letter of response. They show up, and what is completely incorrect, on July 31st, we didn't have any documents. There was no response, not one word on July 31st. All that happened on July 31st, they came in and basically pointed the finger at Mr. Gallo and said he was being uncooperative, which we had addressed in March. At that, and they didn't provide me with the tax returns as they claimed. There's nothing in the record showing they did that. After this trial judge made specific verbal findings of intentional, inexcusable conduct and statements to the effect that I've not seen anything like this, and he said, I'm going to impose sanctions, and I'm going to issue an order, and I want to think about what the extent of the sanctions will be, and I want to review all the file. Now, that's in this record, and that's in general terms what he said. But he told the appellant, you have participated in intentional, inexcusable conduct, and there are going to be sanctions here. And there's going to be sanctions in addition to attorney fees. It was, and at that time, the record indicates, counsel asked the court for leave, or in so many words said, I want to file a memorandum. The trial judge told him, don't file anything. You've had months to file stuff. You were here twice, your client had notice, she had knowledge, she did nothing. And you haven't done nothing as of today. A day later, he starts sending me all these documents and files and memorandums. They ignore that court's order, and that's in the appendix as well. And they submit, and they claim they provided the tax returns. Well, if you look at Shannon Poff's affidavit and Mr. English's secretary's affidavit, they talk about all the problems with Mr. Gallo, and what's it say? He was disorganized, forgetful, and confused. I called his office on June 24th. Where was the affidavit in motion and request to cite Mr. Gallo to court? It didn't exist. It's not in this record as of that time. They did nothing. They just appeared in court with the apparent idea, we're going to give no discovery, presumably trial by ambush, and I'm going to blame on Mr. Gallo.
Counsel, you've used your time.
Pardon me?
You've used your time.
Thank you.
Thank you for your argument. 2 minutes and 58 seconds for rebuttal.
Thank you. Judge Schaefer, let me answer your question that Mr. Richard avoided. Never was there a claim made against the estate of James Poff by Petro Evaluation Service, period. Secondly,
How about the fact that she signed individually? Is that
Well,
important to us?
Well, frankly, no. What she did, it's clear that she was acting in her representative capacity with respect to this property. Why else would she be doing anything on this property if she was not doing it as the executor of the estate? Now, the contract between, or it's a written agreement between Caldwell, who was the scrapper, and Shannon Poff was not even signed by Shannon Poff, it was signed by Kobe Bartram on behalf of Shannon Poff. This is the guy who came to help her decide
Evaluating.
what was to be done. Okay. So the suggestion somehow that she was acting in her own individual capacity and never acting in her representative capacity is disingenuous on its face. Shannon Poff would have no right to exercise anything to do with that property, or no need to do anything with that property if it was not part of the estate.
Was the value that was established by the scrapper, for lack of a better word, the same as the value that was put on the inventory?
Yes. So, let me focus again on counsel's argument with respect to this long, involved statement that he's making about how we somehow didn't do something. The fact of the matter is clear that Mr. Golub would not respond. When you look at the record in this case, the judge obviously decided that sanctions were appropriate under the circumstances. The question is the nature of the sanction. And the case law is clear, the law is clear, that the sanction has to be proportionate to the act or the omission by the party who failed to provide discovery. And it is unequivocal in this record, it is unimpeached in this record, that the facts that I have laid out to you in my initial argument are in fact what occurred. So while he wants to argue that somehow this is trial by ambush, as Your Honor pointed out, this was 6 weeks before the trial. He had the tax returns at that point. If the tax returns showed that Mr. Poff had depreciated, that would go against him. If the facts showed otherwise, he might be able to argue that Mr. Poff didn't own this property that was there, or didn't own the metal materials that were on the site. However, since he had those tax returns, he was in a position to be able to argue that point if in fact this case had gone to trial on the merits. What the court unfortunately did is abuse its discretion in imposing this terrible sanction against Shannon Poff, depriving her of an opportunity to show that she didn't have any knowledge of this material on the site, that she certainly did not willfully convert anyone's assets, and as a result, she should not have been held liable.
Counsel, your time is up.
Thank you. I ask you to reverse. Thank you.
Well, I omitted to thank both of you for coming to Akron to make the arguments today. We really appreciate you accommodating us. Thank you for your arguments today. We'll take the matter under advisement, issue a decision in due course. Clerk of course will certainly mail you each copy of the decision on the day it's released, and you can also find the opinions on the Supreme Court of Ohio's website.